So now going backwards, we move into the plaintiff's argument as laid out by the Justice. 73. I note that there is no evidence that the defendant was receiving any mental health treatment or support at the time of the 2019 or 2020 offending. They're very dancy around the truth in that the offending was a neighbourhood dispute. 72. It was submitted by Mr. Emmett that the court should not infer that the defendant's attitude or beliefs have changed or lessened due to the effective treatment of his mental illness, as the position is equally consistent with the medication having no effect, but the defendant choosing to hide his beliefs so he can be released, particularly given his perceptions stated in his February 2021 phone call with Mr. Hook that the reason he was refused bail was for his adherence to the United Kingdom of Australia's beliefs, at which the Justice has set out now a curial right. This is now the police's notes. Right, because Mr. Emmett is the prosecution for the police, and he's the one that's submitted to the court. Mr. Emmett submitted to the court that believing in who you are before these peacekeepers took control of you isn't in the interests of the defendant. And he's worried that these beliefs will continue because they open up the door to them being on the other side, and that opens the door to those international criminal offences. And we've already seen what International Humanitarian Law Rule 92 actually means. And when we get down to the specifics of this matter, we can very clearly see that these crimes have occurred. So this is a police officer acting like a kindy. They're treating the court like a kindergarten in that they've had their little tanty over some YouTube videos, and now they're having a tanty that there's this organisation out there that has better morals and values than they do. That about sums it up. And then the specific risk to the police here is the sipping of this poison chalice, in that they have always believed they were in the right, and then those that have gone outside of the rules of administration that are on the table might find themselves in a liable position where consequences might not be so friendly. 71. In broad terms, in relation to the relevant Section 25 factors, before incarceration, his behaviours were escalating, as was his high level of fixation and obsession with, quote, the cause. His delusional belief system regarding the legitimacy of the Australian government has real capacity for risk that he will either engage in activity or disseminate extremist ideology to radicalise and influence others. That's a rather wide, tarred brush, isn't it, Matthew Reason and Mr. Emmett? In broad terms, this broad, tarred brush that we're just about to slap, his escalating behaviour, well, he was in the middle of putting together an event. His level of escalation was relative to the event that was being held. The fixation was yours, Mr. Reason. You're the one that was obsessed with so-called the cause. His delusional belief system has been clarified as being curial in nature. Your events have led to a larger crime being committed, at which you admit to, as we will find out again, as we go backwards through this document, to taking command of this situation, in which now you have to speak in broad terms because you have no specifics. You might as well have done the same thing to Amnesty International, Matthew Reason, or the Red Cross. That's what this amounts to. This is really what this amounts to, is a peaceful organisation that sought to brought peace to the world, and turning it into this, a broad brush where the level of fixation and obsession seems to be with the State Protection Squad of the New South Wales state, and then the indicator that there is something they fear at a right of law, a right that can be asserted by the people of the Commonwealth. That seems to make the state protect itself. 70. He was not compliant with his CCO. There is a risk that he may not comply with his CTO. His beliefs and commitments amount to a type of call to arms. To others, with use of social media posts, he has some influence as a leader of the United Kingdom of Australia movement. You're trying to paint this as a thing it's not. It's a little bit more than a movement when it has a curial claim that precedes the claim that you stand in. That's an important factor, that there is a curial claim that precedes. 69. It was submitted that the court should place weight on the conclusion by the risk assessment report author that he is at moderate to high risk of engaging in politically motivated violence. We can see that this Vera report that they are talking about, the author is not really Miss Prince. Miss Prince has stated on more than 10 occasions that she's qualified enough to understand that there is no report. She doesn't have the foundations to make a report, and here is Mr. Emmett putting weight on this report that doesn't have the framework to even be a report. This is admitted in the document. So Mr. Emmett, prosecutor for the New South Wales Police, is lying to the court knowingly, and more than lying, is part of the fabricating of evidence to bring about the view that the defendant is a terrorist rather than a Christian Australian civilian and part of the community. The key link here is this risk assessment report author is a tool, the Vera tool used by Miss Prince. That's the key link here. There is no author to this report because the report did not find any foundations in statutory legislation. It didn't fit the boundaries that they were required to fit. They tried to put a square peg in a round hole.